Time to elevate. You're running on empty with Matt and Tony.
Hey, everybody. Welcome to Running on Empty. I'm Matt.
And I'm Tony.
And we are running on empty. Today we have got, we actually take a little break from our senatorial interviews, which are going to be coming up on our next one, I think. On this one, we're going to be talking about a topic that is in the news a lot today, and that's net neutrality. And Tony, why don't you give us a little rundown of what our interview sounds like today?
Well, we are joined by our, media law guru, and that is Dr. Chris Terry. Welcome, Chris.
Hey, it's great to be back, guys.
Chris has been on our show before. He's a graduate of UW Oshkosh from back in the 90s. He went on and got his doctorate degree at UW-Madison. Today, he's an assistant professor of media and journalism at the Hubbard School of Journalism and Mass Comm at the University of Minnesota. Published a number of articles dealing with the First Amendment and media administrative law, and is quite knowledgeable in all those areas. And today we've got a number of topics we want to get into with Chris, including net neutrality, which is an important topic that most of us really can't define very well. And we also want to talk about the Biden administration's recent attempt, I guess, to get Facebook to quote unquote censor so-called misinformation on their platform. And another issue I want to get into is a few Supreme Court justices have said that maybe it's time to revisit the famous case of New York Times versus Sullivan. That's the case that makes it very, very difficult for so-called public figures or public officials to sue any media source for libel. And I want to, talk about whether or not it's time to revisit that. But Chris, thanks again for being here. And why don't we start off with net neutrality? What is it and why is it back in the news?
Sure. Well, it's back in the news because last week, Joe Biden handed out an executive order that went out to the administrative agencies. The order itself was primarily about trying to promote competition. But there's one paragraph, it's basically 3 sentences long, that directs the FCC, the Federal Communications Commission, to start a rulemaking process to reinstitute Title II net neutrality, as had been on the books before the Trump administration. Net neutrality itself, though, is it's just a term, actually. It was coined by Columbia professor Tim Wu to describe regulatory practice for internet service providers, or ISPs, and how they manage traffic that moves through their network. The idea of net neutrality is that all content that moves through there, all legal content that moves between you and your ISP and the internet, remember your ISP is sort of the traditional middleman in that arrangement, gets treated the same way. And we're having this dispute now because in 2015, under the Obama administration, after much consternation, the FCC under Tom Wheeler handed down a set of rules called Title II rules, which basically treats internet content the way an old phone line would have been treated back in the day, which common carrier status. Now, that's a radical oversimplification of what that provision did, but for the sake of argument, is that it basically means that you as the consumer get to pick what content comes to you, and that the ISP can't slow or block you from access to content that you want. Now, there was a lot of problems or objections, perhaps, to that approach, primarily from the ISPs and internet industry. And they tried to get it overturned. And it went to court 3 times. It was upheld by the DC Circuit. It was upheld on a full panel review. And then the Supreme Court did not give it cert. That was the US Telecom case. Okay. But then Ajit Pai took over the FCC when Donald Trump was elected president. And although the rules that had been passed in 2015 were declared to be constitutional and valid, the FCC under him in 2017 passed a different set of rules that were basically net neutrality in name only. And they called it the Open Internet Freedom Order.
Chris, before you continue, let me see if I can simplify net neutrality, see if I'm on the right track here. Sure. Because of net neutrality, if someone goes to Google and in the search engine, they put Chris Terry and net neutrality, because of net neutrality, this podcast might actually show up in search results, right?
Yeah, absolutely.
Okay. Without net neutrality, what happens to a podcast like Running on Empty?
Well, it depends. In your Google search example, it would depend on whether or not Google search puts you in there. But where net neutrality actually works is not at the search engine level, but it's at the direct connection between you and your ISP. So I'm going to say some bad things about ISPs today, internet service providers, and they might not want people to hear that. They would have the ability to block you. Now, Google's kind of a weird situation because Google is primarily a search engine, but they also operate fiber ISPs in a few locations, Austin, Kansas City, et cetera. So they would have that power. Google's not really notorious for being one of the major blockers. Those tends to be companies like Comcast, Spectrum, Time Warner, AT&T, Verizon, sort of the four worst companies in America. Well, annually, those groups are usually the worst rated consumer companies in America. But to finish where I was going is when Ajit overturned the rules in 2017, that went to court, and the court said, well, it was okay as a policy decision to change the rules again, but there were some problems with it. And those problems have not yet been resolved by the FCC. Several issues were remanded to the FCC, one dealing with public safety, one dealing with the Lifeline program, and another one that dealt with just how these two sets of rules would interact. And that hasn't been resolved. So the FCC does have net neutrality on its plate before Biden's executive order, but now there's a lot of push to see us return to that 2015 rules, which is complicated by the fact that the court said that would be perfectly okay. But what Joe Biden did was he complicated the matter further by requiring that the agency do a full rulemaking proceeding to overturn that 2017 rule, which probably means that nothing happens on net neutrality for at least this year. And primarily because there's no fifth FCC commissioner yet.
Why would he announce that before they even appointed a commissioner?
Well, there's a lot of consternation among the policy folks on both sides of the aisle that there hasn't been a fifth FCC commissioner, because the four that are there now, one is an interim chair, that's Jessica Rosenworcel. Jeffrey Starks is the other Democratic commissioner, and then Brendan Carr and Nathan Symington are the Republican commissioners on there. They don't agree on basically anything. And at a philosophical level, they're fundamentally different, but on a policy level, they're also done. So even things that aren't necessarily as politically charged as net neutrality has become, tend not to get done. And there's a lot of problems. Broadband deployment alone should have ensured an early fifth commissioner pick. But it seems that the Biden administration feels like they spent some of their political capital getting Lena Khan appointed to the chair of the FTC, the Federal Trade Commission, and hasn't made a move. But remember, net neutrality wasn't always associated with the left. It was actually a Republican administration, Michael Powell, under the second Bush administration, who actually proposed the idea as a regulatory solution initially. It's sort of carried some water since then on the left as opposed to the right, but it was always seen as a competitive protecting practice, at least initially.
Based on Joe Biden's history, wouldn't we expect that his appointment to the FCC would be some very pro telecom industry kind of toady?
Certainly not outside the realm of possibility, but there hasn't even been a name floated.
Right. You remember what was his name? Julius Janikowski?
Right.
Who was Obama's first guy?
Yeah, he was.
The best thing you could say about him is that he was probably better than Michael Powell or.
That's actually a debatable point. Janikowski was sort of next in line for it. Janikowski had worked on the staff of Reed Hunt, who was the Clinton era FCC chair, who implemented the 1996 Telecommunications Act. And because a lot of those things were still occurring when Obama became president, Janikowski was a logical pick. Mm-hmm. But I mean, even Tom Wheeler, the guy who oversaw the implementation of the Title II regulations in 2015, came from the cable lobby.
Right.
I mean,
so from a media consumer perspective, right? So 99% of us are, media consumers. What kind of person should we want in that position?
Well, you'd want me. I'm the answer to that question. I keep saying on social media that if they can't find somebody, I know a guy.
Yeah.
But you really want somebody who takes the FCC's authority seriously. I fundamentally disagree with Brendan Carr on many, many issues, but he at least takes his job seriously. I disagree with how he takes his job seriously, but he does take his job seriously. And Michael O'Reilly, who was FCC commissioner, Republican FCC commissioner until he was basically let his term expire under the Trump administration. That's how we got Nathan Symington. O'Reilly was a serious guy. I mean, he was an admin law nerd. He took his job seriously. So what you really need, not necessarily somebody ideological, but somebody who's going to recognize that the FCC has authority and is willing to use it. And that's really what's been lacking at the agency for 15 or 20 years is you just haven't had a hard commission of people who were at the same time who were willing to take FCC authority seriously. You had Michael Copps was sort of, he was definitely an ideologue, but he definitely took the role he was supposed to play very seriously. And, that sort of ebbs and flows at the commission. I would rather have somebody I disagree with who understands that the FCC has authority that it's supposed to wield in that position than necessarily an ideologue who's just not going to take the job seriously.
Right.
And that's what we got. We had plenty of that in the Trump administration, and plenty of it. There's plenty of blame to go around in the two administrations that preceded that one as well. So, it's a matter of administrative agencies have to do what they're told, right? Congress tells them what to do, and then they're in charge of doing it. It's kind of like giving a kid a chore in many ways. Right. And what has happened is Congress hasn't really taken its parental duties very seriously, and that's certainly true on net neutrality.
Yeah.
In that the law that Congress tells the FCC to regulate the internet with is from 1996, which I don't know if you noticed, the internet looks a little different than it did in 1996.
Yeah, it does.
But, beyond that, you need kids who take their chores seriously. And those are hard to find. I think the Biden administration got a little derailed. I think they wanted the former commissioner, Manil Clyburn, to be the FCC chair. And she pretty much said, no, thank you. And they didn't really have a backup plan on that. Clyburn was an excellent commissioner when she was on there. And like I said, I disagree with Brendan Carr. He's a good commissioner. I disagree with him. Nathan Symington a guy's a joke. He barely knows the job he's supposed to do.
One thing the Biden administration has gotten, I guess, derailed by is maybe it's too strong of a term, but I think their obsession with, say, Facebook. And, the press secretary, Jen Psaki, came out and said that there are, 12 sources that are spreading misinformation on Facebook about the virus and about the vaccines. And Facebook has got to do something to rein in this misinformation. What's your take on the federal government essentially trying to coerce a private company into monitoring the content on their platform?
It is horrifically dangerous in First Amendment terms as a standard. And regardless of what I feel about vaccine information, the principle here is a pretty simple one. Do we want the government telling private platforms what they can and can't do? And most importantly, when you break it down to its component atoms, what you're talking about is, should the government be able to use leverage, state action, to force things like this? Now, the reason that this occurred the way that it did, of course, is that there's very little the government can do to Facebook that would meet the First Amendment in order to get rid of that content. So they tried to shame them into doing it ethically, and that's why it became a big deal. But the content that Facebook posts is posted by third-party content, right? Facebook generates very little of its own content. If we just stop putting things on Facebook, Facebook would essentially die very quickly, because they don't produce their own content, right? They rely on content produced by others. And I mean, they've become, in sort of the traditional parlance, they're just a middleman for the delivery of other people's stuff. So Facebook is not, by law, Facebook is not responsible for content that's posted by a third party. That's their Section 230
that's the Section
immunity.
230 protection, right?
Right. So although Facebook probably should do a better job of content moderation than they do, and that's not just true for vaccine misinformation. There's all kinds of stuff on Facebook. There's that, the should, and then there's the can we make them do that? And as the law stands today, we cannot. Now there's winds of change on that are blowing pretty hard.
There's even like 7 or 8 bills in the Congress that would change
27.
230.
27? Wow.
27. There's 27
Holy
bills
cow.
introduced in the last 18 months that would in some way or another modify Section 230. The most recent of which was from last week. Minnesota Senator Amy Klobuchar passed or introduced a bill that would remove Section 230 immunity in cases of vaccine misinformation reposting, which is a really dangerous. I mean, I understand the intent.
Yeah.
But that is like the first brick in the slippery slope.
But like, and you do that, where does it stop then, right?
Well, and my point on this to my students is always very simple. You might agree with the people who are saying this now, but would you have just dial it back 8 months? Would you have wanted the Trump administration to be making content-based decisions for content about vaccine misinformation?
Oh my God.
Right? I mean, that's what you're talking about.
Right.
And, it's a hard principle to hold to these days because there's an awful lot of really awful speech on the internet. I mean, there's stuff that, I mean, it takes a lot to get me, but analytically, there's a lot of bad content on the internet. Sure. But you have to hold to the principle that you might like the people who might make these content decisions now, but what about 4 years from now?
Exactly.
Right? Would you want a senator, soon to be president, Tom Cotton, to be making these decisions?
Oh God.
Okay, but Matt, that's exactly my point.
I get it.
You got to hold to the principle that it's not the way how it is right now might work for you, but it might not work for you down the road. So you have to stick to that sort of core principle that you got to defend the speech, even if you don't like the speech, because if you give people the ability, people being the government, the ability to just decide what's okay, only takes a small shift in government for that to be problematic.
What's that old saying, Chris, that a lie has traveled halfway around the world before the truth has its boots on or something?
Yeah.
So like conspiracy videos will get tens of millions of hits and downloads. Accurate information sits in isolated territory somewhere. So how do we handle that as a society?
Well, I mean, we have to live with it. As it stands right now, we have to live with it. The hardest thing, and I'm actually writing a paper on this right now, the hardest thing to convey when it comes to this argument in the digital age is that misinformation has always been around, right? There's always been yellow journalism. There's always, in my summer school class, I just talked about the War of the Worlds broadcast, right? I mean, that, these things have always been there. It's just the speed at which they can travel now that's fundamentally different. But you have to be very careful in any First Amendment involved situation about what power you're willing to give away. Because if you notice anything about government, they don't tend to give back power that you give them, right? If you give something up, it tends to stay in their hands. And I for one, I am willing to endure an awful lot of bad speech if it means that the government can't mess with speech that I think is really important. Now, that's a principled point of view today. It's not a really well accepted one. It was 20 years ago, but it's certainly changed in that time. But in terms of misinformation, if you want to regulate that and you want the government to regulate that, you're giving the government to decide the power what is and isn't misinformation. And in
So
my
back in the day-
lifetime,
Well,
you know-
back in the day, Chris, would you have been against, I guess it was a deal that was made between the government and, TV networks to take cigarette advertising off the air, right? We don't have cigarette advertising on network television, correct?
that's correct.
All right. So would you have been against that?
Well, I was against the idea behind it, but not the implementation of it. And part of that is that you're talking about a licensed medium at that
Mhm.
time, which the
Sure.
government does have additional authority over. Now that's picking straws, I get it. But you have to consider that if you give the government the ability to decide what is and isn't speech, think about just in our lifetimes. Would you have, it was bad enough. The propaganda we saw ahead of the invasion of Iraq was bad enough. Would you have wanted the government to be able to decide that any information didn't agree with that what could be censored? It was
No,
bad
of
enough
course
as
not.
it was. Okay, but it's the same idea. If you want misinformation, however defined, or conspiracy theories to go away online, there's only two ways to get there. Number one is to get social media platforms to be more socially responsible and do a better job of content moderation, which flies in the face of everything economic that they stand for.
Mhm.
Sure.
Or you give the government the power to do it. Right. And that means that you have to live with the government's authority to say, you know what, this particular really uncomfortable piece of information, that's really just misinformation. We'll just make that go.
But the
And
moment the moment they do content moderation, Chris, then they are like traditional publishers, right?
no, it's no different than kicking out a rude party guest. It's really all it is. I have people over to my house. One of them's rude to everybody else. If he's my friend, I can let him stay and everybody else can bugger off, or I can ask him to leave. I hate to simplify the metaphor about that, but you don't have a right to use a social media platform, right? You don't.
Right.
You have the right to speak,
Mhm.
but you don't have the right to speak on a social media platform. It's no different than those shopping mall cases from when I was one of your students, right? That these are private places. They have a public face, but they're really at their very core no different than your living room, right? They're
Right.
private. They're private. And
Sure.
broadcasting, of course, is in a different category because the government licenses that and controls that some. Now, part of the objection to net neutrality is that some people see that as a slippery slope to the government having similar controls over the internet. We have a case that prevents that from happening for now. That's Reno v. ACLU. The Reno v. ACLU determined that the internet was a newspaper in 1997. And that's the only thing that's keeping that in place. So
Right.
to get to what you're talking about, Tony, you would have to have the Supreme Court overturn Reno, right? Which would be kind of a big deal. And then implement some sort of control mechanism over that, like the FCC had. Now, the other argument against that, of course, is setting aside the First Amendment argument, is that do you trust a government agency to do a good enough job on that? And my counterexample to this, of course, is the FCC's enforcement of indecency. They had these wide-ranging rules all the way back from before Carlin's monologue in the 70s. And in all that time, Janet Jackson's boob at the Super Bowl, all that time, they only fined people 108 times, right? They've had that authority to do that since 1927, right?
Mhm.
And you can't tell me that if you watch broadcasting or listen to broadcast radio, that there isn't indecency at basically every juncture.
Yeah.
I think of
Where's
the
the
number of-
accountability behind it, though? That's my biggest question. Is sure, you can say what you want to say, and we don't necessarily want people to be censored in what they say, but there has to be accountability, especially if it's blatant lies. One of the articles I saw the other day, and again, this is all on on the webs, on Facebook and whatever. But today Tucker Carlson says no, the vaccines don't work. Tomorrow he says they work. The next day he says no, they don't work again. Okay, this is killing people with his stuff. So where's the accountability against people like that?
Well, you're in traditional First Amendment terms, you're putting the accountability on the wrong person. The accountability actually has to be on the citizens to expose themselves to other forms of information. The weakest link in the communication chain isn't the misinformation that's out there. It's the fact that people have put themselves into bubbles and don't expose themselves to alternative forms of information.
Sure.
So dial the clock back 20 years. The limited number of sources of information you had actually competed against each other. And because there were only so many, you actually were likely to be exposed to different points of view that
Sure.
way. Now that we have this basically fire hose of information that never turns off, it's easier to just put yourself in a box with some information. And what we see when we study this is that lots of people have put themselves in a box where they already agree with all the information in that box. The weakest link in that agreement, that arrangement, is of course the citizen. And unless you're going to like sort of Clockwork Orange style people to make them watch C-SPAN or something like that, you're not going to change that by limiting the amount of speech that's available.
Right.
And again, that's a principled point of view, right?
Yeah.
It becomes less practical as time goes on. Go ahead. I'm going to say,
go to a different topic. Go ahead.
I was just going to say, there's a lot of media law scholars, people I have a lot of respect for, who are increasingly disagreeing with my sort of Nickel-Johnian absolutism here on this, because it is a principled stand, right? There's a lot of speech on the internet I could do without.
Yeah.
But as somebody who really believes in how the First Amendment is supposed to work, we're really just going through the internet's sort of legal time of puberty right now. The courts are really wrestling with this. The cases that the court chose not to hear, the court cases that got decisions this year, right? The court is really wrestling with how to treat the internet right now. And the only thing holding back some significant change is this decision from 1997, which clearly says in the decision that if situation warrants a change, it can be changed. We're not there yet, but we're getting there.
But people like, you mentioned Professor Mickeljohn, he was a great, actually a Wisconsin professor, great civil libertarian, First Amendment scholar. But, people like him, their assumption was that you throw every idea into the mix and ultimately the truth will prevail. Well, that's nonsense. We now know firmly that the truth does not prevail. In fact, more often than not, it doesn't. So if that's the case, if falsehood can maintain a grip for decades, maybe even centuries at a time, what does that do to the kind of Mickeljohn theory?
Well, it certainly makes it more principled than practical, as I said.
Yeah, it's exactly. You've mentioned the Supreme Court a few times, and I don't agree with Clarence Thomas and Neil Gorsuch on pretty much anything. But the two of them have come out recently and said that it's time to revisit the famous New York Times versus Sullivan decision of 1960. Was that
64.
64. And, that decision was the one that allows pretty much anyone to say anything about any person who's defined as a public figure or a public official. Correct? I mean, before New York Times versus Sullivan, politicians, corporate leaders, and others with power would basically always threaten libel suits against anyone who would say anything critical of them, right? Now we've gone pretty much 180, and anyone who's defined as a public official, I mean, you can have any lie said about you, and there's no recourse. And I kind of agree with Thomas and Gorsuch. I mean, for example, Matt and I are interviewing United States Senate candidates from Wisconsin. I would say every single one of them has already had numerous lies told about them by the Republicans.
Yeah.
And because they're public officials, all right, just tell the truth about yourself. I mean, is that really what New York Times versus Sullivan was supposed to do? Have political hacks just attack people at random?
Well, I think you've oversimplified it a bit.
Of course.
But the distinction matters. It's not that a public figure or actually it's a little harder for a public official, but a public figure to recover damages isn't eliminated by New York Times v. Sullivan. What it does is it makes it really hard.
Yeah, the actual malice standard.
Right. Now, for your listeners who don't know, New York Times v. Sullivan is a case that came out of the 60s. Sullivan is a police commissioner. He sued the New York Times, not for content that the New York Times itself produced, but an ad that was run by a group that was trying to raise money for Martin Luther King Jr.'s defense fund. In the ad, they describe a bunch of events that happened during civil rights. Imply is probably the correct word. They imply that many of these things were committed by Sullivan himself, dogs, chains,
right,
etc. Some of which is true. All of the things that happened, but Sullivan himself was not, who was a pretty bad figure, by the way, was not responsible for all of the things described. He sued in state court, and because we didn't have an actual malice standard, then he won a huge judgment against the New York Times for something that they actually only just ran in the newspaper. It was an advertisement rather than editorial or news content. And the court looked at that and they said, well, this was a group that they had worked with before, the New York Times had worked with before, that they had reason to believe that all these things had occurred, and they didn't necessarily imply that it was Sullivan in the way that they did. And the court develops the actual malice standard. But actual malice is the fault requirement in a defamation case. There's actually 5 others, right? It just is the part that makes a case for a public official or public figure very hard to claim damages on, because under actual malice, the plaintiff, the person who's been defamed, has to demonstrate that the person who made the comment or wrote the comment, depending on whether it's libel or slander, knew it was false when they made that claim, and or did so with reckless disregard for the truth.
right.
And politicians have recovered damages under actual malice.
Not many of them, though.
Well, Connaughton, one of the first, right? Ohio judge, clearly defamed by a person. Journalistic organization just makes no effort to verify these stories or whatever. And they're sued for that, right? And the newspaper loses in that case. But what you have going on right now is something different. What you have Republican operative A or Democratic operative C making a wild claim about their opposing people. And you have journalists republishing that comment verbatim and just saying, this is what Democratic candidate C said, this is what Republican operative X said, without any sort of meaningful consideration of whether or not those comments are true. That's different than defamation. The problem there isn't the defamation per se. The problem is the journalists are not doing their job to vet the claims and give sort of the thumbs up or thumbs down on it. And in that, I'm very nervous about reforming the actual malice standard. But beyond that, I'm very nervous about people like Thomas and Gorsh being in charge of reforming the actual malice standard. Well, no, I mean, this has been a debate that really broke out over the last 5 years. People like Donald Trump were arguing that we can't just sue people when they criticize us.
Right.
And what we saw prior to actual malice is what you described before, is that rich people who didn't like what was being said about them, even if it was true, would file a lawsuit just to get the other people to shut up.
No, I know that Thomas and Gorsuch and Trump and others are bad faith actors, right? I know that their motives are probably not pure in this. But having said that, in my lifetime, I have seen the public discourse so completely disintegrate, right? So, is it possible to recognize that there are bad faith actors leading the charge, but still say something has to be done in our defamation and libel law to try to rein in some of this crap?
Well, it's much like the earlier discussion we were having today. It is an either or prospect, right? There's very little middle ground that makes it acceptable. And from my perspective, you're always better having more speech, even if that speech is awful, than less.
Right.
And again, that's sort of a principled point of view. It's not as practical as it may have been at one time or another.
Right.
But if you get rid of the actual malice standard, the impetus to be able to criticize public figures and public officials will go away because they have the resources to do something about it when they don't like what's being said. Even if they can't win, just putting the burden on the people who are speaking out against them can basically silence those voices. And that is a way worse outcome. Now, if there is some sort of middle ground on this,
right,
I mean, the devil would be in the details, of course.
right.
I would be willing to think about that. But this does seem like one of those either or prospects for public figures and public officials.
Yeah.
And of course, there's the multiple standards within those things. If you're a public official, basically anything can be said about you.
Sure.
There's different categories of public figures where different elements apply. But a way to fast track a defamation claim would actually be more useful than a revision in the current defamation client. Because if I say something defamatory against you, Tony, and I only said those things when I was in your class, by the way, but if I said something publicly defamatory against you, you're in kind of a bad spot, right? You're a former politician.
Right.
You're obviously a public figure on a lot of issues. You'd have very little recourse to come after me.
Exactly.
But even if you knew I had made that statement, you could demonstrate that I had made that statement with reckless disregard for the truth, or, with knowing that it was false. Even if you could get in my head and do that, it would take years before you could recover damages for that. And the damage is already done at the point that the speech is out there. So I don't see how reforming actual malice fixes the problem. Would there be a better way for this to be fixed? Yes. People could take when an operative or another candidate or somebody else says something and vet that claim before it's just published verbatim. Right. Because it doesn't, even if it can be made demonstratively false the next day, it's already out there. Right.
Yeah. Can we do the same thing on the internet too? Because people see a title, they click and move it on. It's the exact same problem with the internet, is that look at this. See, this proves my point. Well, you didn't even read the article and you forwarded it on, hence the spread of misinformation. And here we are back to the beginning.
But I mean, these things are all related, right?
Yeah.
You have to live with bad speech if you believe in the First Amendment, right? It's the outcome, right? You've got to live with some pretty awful people. But remember, fighting over free speech in the gutter or the sewer means that everything above the curb is protected. And you got to protect some awful people. You really, really do. But if you're protecting those people, if you're protecting the Westboro Baptist churches and the Anthony Alonises and all those kinds of people, boy, there's an awful lot of speech that we're not even trying to do anything about and make go away. And that's a good thing. Is it great? Is it a great thing? Yeah, it is. Because where we draw the lines on these things has gotten so far down into the sewer in many ways that the really important speech is still out there. And again, the weakest link in this argument is the citizens who don't expose themselves to alternative points of view. And I don't know how you can regulate that aspect of it, short of Clockwork Oranging them with C-SPAN.
Yeah. All right, Chris, we are just about out of time. Thank you so much for being here. We want to, have you on as a regular. As I said, you're our kind of like media law guru here at Running NMT. And I think over the next couple of years, there's going to be some very, very major issues going on. We mentioned net neutrality, but there's going to be many others coming up, right?
The Section 230 debate is going to get hot here before the end of the year. Definitely.
All right, cool.
Definitely want to have that before the end of the year, then have you back for that interview.
All right. Well, thanks again, Chris. We'll talk to you again soon.
All right. We'll see you guys.
All right. Thanks so much, Chris. Take care. Hey, Tony, I really enjoy talking with Chris pretty much every time, even when we're not doing like interviews for the actual show. I learned so much from him. And the fact that we were both your students is pretty cool.
Well, it's always a joy for me to speak to both of you guys. It's just so incredible to see what you're adding to the society. And, Chris is just, I tell you, I've never met a First Amendment scholar who's got such an encyclopedic knowledge of cases. That guy, we talked about New York Times versus Sullivan. This guy can dig into the facts of the case like he just read Black's Law Dictionary, like,
Right.
a few hours ago. It's just amazing. I'm so proud of him.
Yeah.
But he's raising issues that most Americans don't think about, and yet they impact us every single day.
Right. Right. And I really want to talk with him in a couple of months as we get closer to that, the decision on this, Section 230 as to what's going to happen with it, because, I think it kind of goes back to the, what we were talking about. It was talking about getting rid of the filibuster. And,
Right.
right now, some people want to get rid of it. And okay, but when you need it and it's not there, so it is a double-edged sword, and this goes the same way. A lot of people want, some of these reins pulled in, but then what precedent is that setting? Where do you stop? I think I asked that earlier. Where do you stop when, if you shut this down, what's next? And it's fine now if you agree with it, but what happens if it's something that you don't agree with, and all of a sudden now you're really upset about it? So it's going to be really interesting to see where this conversation goes in the future.
Yeah, I think what happens with partisan politics, though, is that Democrats always worry about, oh my God, if we do this, what happens when they get power? And then when the Republicans get power, they never have that conversation.
They don't care. They're like, we
like,
got
no,
it
let's
now.
do it.
Yeah.
That's the thing. And it's, especially on something like the filibuster, correct?
Right.
It's not like you're changing some constitutional text, because it's not in the Constitution.
Right. Exactly.
It's a tradition.
Mm-hmm. Yeah.
All right.
So
changing it should not, they use phrases like the nuclear option. We shouldn't have to use that language.
No.
It's something that's been used for a lot of years. It's not in the Constitution.
No.
Doing away with it should present absolutely no problem. Don't make it sound like you're dramatically changing the nature of the country.
Sure.
Because you're not.
Exactly.
Oh,
wow. Well,
anyway.
The future will be interesting, especially on these topics. So looking forward to what's coming up next with Chris. And
we will all have to stay elevated.
We'll have to stay elevated. We'll see you next time, everybody. Take care.
You're running on empty with Matt and Tony.